even after it was legal, a judge like, for example, Judge Pomerantz, I'll call her out, she would make a big stink about it. But part of it really is that you need to understand that a lot of these lawyers and judges have known each other, and so I wouldn't say there's a cabal, but there's a cabal. I've had a recent case, for example, where this guy keeps harping on the fact that his ex cheated on him. Who cares? It's irrelevant. Look, what tells you, what fact is it that kind of demonstrates to you why cameras matter in family court? It's the resistance you get from lawyers and some judges.
Welcome everybody to Our Nevada Judges. Today we're going to have a little bit of fun. I have an attorney here. His name is Alex
Ghibaudo.
Okay. Thank you for coming in, Alex, and agreeing to talk with us. I appreciate it.
No problem.
What kind of law do you practice? What is your normal?
Primarily family law.
Yeah.
Yeah. So primary practice is family law. I do appellate work, some criminal law, but I'm not into doing that anymore. So
Okay.
It's primarily family law.
What made you decide that you wanted to do family law?
It just falls into your lap, right? I mean, that's the easiest. That's the easiest type of case to get. You don't have to advertise a lot.
Right.
It just comes to you. There's a lot of custody disputes and divorces out there, so it's just pretty easy to get cases and clients.
Well,
and I just fell into it and just started doing it.
I understand. Yeah, that's how I got here. So one of the things that I think is not everybody can afford an attorney.
Right.
And so some people say, well, I watch Perry Mason, so I know about the law. I'm going to be my own attorney.
Yeah.
What's the pros and cons there? What's your opinion?
I mean, I don't think there's many pros. It's a minefield. If you don't know the rules, you can lose just because you don't know the rules of procedure. You can lose, like I often see people in family court representing themselves, making arguments that are just irrelevant, annoying the judge because they don't want to hear those irrelevant arguments. So I think that the difficulty is that they don't know what the process is.
Right.
And then they don't know the substance of the rules, and that's what gives you the relevance. What's a relevant fact? What's not? So, for that reason, I think it's pretty difficult for people to proceed on their own. That being said, I've seen people in court do far better than lawyers because they know their own case well.
Right.
They're reasonable, and so they're not making crazy arguments in court, not pushing issues or cases that don't need to be pushed. So, cut both ways.
But you better know what you're talking about before you walk in the door, right?
You should try to do some research beforehand and figure out what the process is, how to proceed, and what substantive rules you're using.
And you're talking about mainly family court. I mean, I don't think if you're going into a criminal court that.
No, you'll have a lawyer no matter what.
Yeah, because there, if you can't afford a lawyer, one will be appointed for you, and anything that you say no. See, I watch Perry Mason. Yeah.
Yeah, the criminal law is a lot different. If you can't represent yourself, you will be appointed a lawyer. It's not the case in family court.
So what's the alternative for people who really seriously cannot afford an attorney and have to go into family court? What is there? Is there an alternative for them? Is there something that they can do in lieu of?
Well, I mean, the first thing I'd say is avail yourself of the resources that are out there. There's a self-help center there. They could be helpful in giving you the documents that you need for certain hearings or proceedings, or to make certain proceedings or hearings happen. There's a lot of websites out there that have good information. One of them is like Marshall Willick has a website, and he's got a ton of information on there. Read the rules. They're not that hard to understand.
Yeah.
There's the Nevada revised statutes, the local rules, 8th Judicial District Court rules, and the Nevada rules of civil procedure. Those are the three that you need to use. And use them. Try to understand them. But mostly just there's a lot of there's like the UNLV's law school's got a clinic on certain things. If you can't afford an attorney, you can always go to legal aid, and they'll either, if you qualify, get you an attorney, or they'll reach out to the community and see if there's anybody willing to take on a pro bono case. I've done that several times. So yeah, that's all they can really do to try to get themselves up to speed on what's going on. Watch videos like this. Like, I can just go through the process really quickly so people understand what they're looking forward to. That's it, really.
Yeah.
I mean, that's the problem, is it's all the information is out there, it's all over the place, and then you got to get to it and understand it, and know where to look. Otherwise, if you look up the Nevada revised statutes, for example, they're online, but there's like hundreds of chapters and volumes, and you don't know where to look.
Yeah. Well, and the other thing I think, and this is just a personal opinion, so I don't know if it's true or not, but if you are in the middle of a case or you're part of a case, you have a lot of emotional involvement there.
Yeah.
Where an attorney does not. I mean, they can look at things more objectively, and they can tell you whether you're full of crap or,
The good ones
you can't
will.
go. Yeah, right. You can't go down that road.
Yeah, I mean, that's the value, obviously, of having a lawyer. First, they already know the procedure. They're doing it all for you. They're required to talk to you about the facts of your case and whether you can accomplish what you want to accomplish based on the facts and the law. Good lawyers will tell you not to go down a route that you're insisting on going down, because it's not going to do you any favors. They'll know what facts are relevant, which ones aren't. So, again, if you want to do it yourself, you can avail yourself of a lawyer. I think that, like, for example, the Legal Aid Center has an Ask a Lawyer program every Thursday. And as you're going through your case, I would say use that, before you want to make some move or do something. There's a lawyer you can ask for free, whether that's...
Well, and almost all attorneys, or most attorneys, do some amount of pro bono work. Is that true?
I don't know the percentage, or I know I do. I mean, I know I've taken on in the last couple of years at least 3 or 4.
So if I was in a situation that I needed an attorney, I couldn't afford one, where could I go to find one that might do pro bono cases, or of the whatever kind of case I'm involved in?
I think you can, like, first you go to the Legal Aid Center of Southern Nevada, because like I said, they have requirements as to who qualifies for representation, but if you don't, ask them to see if they could get you a pro bono attorney. Because, like, for example, I would get emails from them, hey, I've got these cases, are you willing to do a pro bono case? These are all the cases that we have. And you can pick one and say, yeah, I'll take it or not.
Yeah.
So
Okay.
you can ask them to reach out to the community. I don't know if the state bar would help, but maybe you call the state bar and see if they have a pro bono project, or they have pro bono lawyers that, have volunteered their time to do that kind of stuff. They're out there.
So you do a lot of work in family court, and there's been a lot of talk about family court here in Southern Nevada's kind of has its problems. Do you find that to be true, or what are your feelings there?
I mean, problems is a general statement. What problems might...
The family court system is screwed up here in Southern Nevada. And what I hear most from attorneys is that if there's any way you can avoid going into family court, avoid going to family court. Find another way.
Absolutely. I mean, you have private mediation you can engage in prior to even starting a case, and seeing if you can work things out that way. Talk to your ex or your spouse, see if you guys can work something out, because if you get lawyers, not only is it going to get expensive, but it's going to get contentious, because a lot of lawyers like to write their pleadings and their motions in a really aggressive way, and it generates a lot of bad blood. It doesn't need to be so hostile in motions and pleadings. Like, I'll get a motion, I have to forward it to the client, and it just has a million accusations that are couched in the worst possible way, make you look as bad as you possibly can.
But isn't that to get a reaction? I mean, isn't the purpose of that, or you're trying to get the other side to react in a negative manner?
There's no strategy behind it. I think a lot of lawyers are just piss poor writers, and they don't have good judgment.
So all attorneys should be required to take a creative writing course?
Problem is a lot of attorneys just leave it to their paralegals to write stuff, for example, the one motion, there's a complaint, and then you're going to answer and you're going to do your counterclaim. There'll be a reply, and right after that, you'll get a motion for temporary orders. And that's the motion where you're going to ask for temporary orders for custody, for visitation, for child support, attorney's fees, whatever it is that you're looking for temporarily pending trial. You're going to put in that initial motion. And usually what lawyers do is they'll write a big fat fact pattern, and it's just, dredging up dirt. It's like, these are all the problems that this person has, and they couch it in the worst possible terms. And so,
And it's not necessarily true.
It's almost there. I mean, look, if you're in court and you have two diametrically opposed positions, somebody's lying, right? The lie is there.
I would think.
Yeah.
I mean, if I was a judge, I'd say, well, one of you guys is full of it,
Right. And that's the problem with putting together a really aggressive, shitty motion that just throws dirt at the other side, is that ultimately the judge is going to see that one or the other side is a liar or not credible, and that's going to really hurt you over the long run.
I'm sure you've heard some of these. I had heard that there's a push by some people to make family court a jury trial situation, and I don't see how that could even work. I mean, I don't see that's a good idea at all.
It's not going to happen. It's been tried before. The rule that these cases are bench trials, basically what they call them. It's been challenged. The Supreme Court has failed. I think in a lot of ways it sucks to have just one person hearing both these initial motions where they're slinging mud at each other, and then be the one that's trying to find actual facts after presentation of actual evidence and testimony at trial, right? You're already polluting that judge is already tainted with, allegations that were made before that maybe later they're not necessarily proven, but I think in the judge's mind, it doesn't go away.
Yeah.
So a jury would definitely alleviate that problem, because they'd be responsible for determining what facts are true or not, and then a judge, like in the criminal context, would be the one that sentences, that issues a sentence based on those
Or why not a
facts.
tribunal? I mean, you have 3 judges or 2 judges or something like that. Because this all came about because
you double and triple the problem. Then.
Yeah, you're right. But because the reasoning behind this was the judges in family court are so bad. And that's not me. I'm not saying that. You know me. I don't know any of those people.
The word is out there. Yeah, there's.
But the word, like you say, there's a lot of people running around town saying,
I think a lot of the people that say that are the ones that got bad outcomes. I'm not going to say that every judge is perfect, but they only have a limited amount of time to hear your case because they have so many of them. So if you're not prepared going into it, you're going to lose just because, you're not prepared and you've taken up too much of the judge's time, or you at trial don't understand that you only have a limited amount of time and you've got to prepare your case accordingly. Are there bad judges? Yeah. I mean, I think some are brighter than others, obviously. That's the case with anything. There's a lot of smart lawyers, there's a lot of crappy ones,
Yeah.
I think overall, I would say honestly, I just have a problem with maybe 1 or 2. But the problem really is that they have a lot of discretion. They have almost too much discretion in making these child custody, particularly, decisions. And so, there's a body of rules and laws that they're required to look at. But if they have massive amounts of discretion on how to look at each fact that's presented, that's a problem.
Well, they have to have a certain amount of discretion, though, right?
Well, sure.
I mean within certain
some
parameters.
bounds, yeah. the problem is that they have too much, I think, in family court. So you'll have a list, for example, the best interest factors. They're NRS 125C 0035, subsection 4. It's a list, A through L, I think it is. And that's going to be your substantive law when you make a determination of custody. So the facts that you develop or the facts that you want to use have to be relevant to those factors. Not an exhaustive list, but it's those are the ones that are required to look at. You present one fact to one judge and they weight it differently.
Yeah.
To one judge, this fact matters, to another, not really. And that's where also a lawyer will help you too, is because they'll have experience before those individual judges and know what matters to them and what doesn't. So, for example, you have a lot of issues where one parent or the other is withholding the child,
Visitation. And not
visitation
letting the other-
issues, yeah. To some judges, that's extraordinarily, to all of them really, but to others, it depends and they'll blow it off. It's like case by case, it's hard to determine because of the discretion they have, what actual facts are going to matter to that judge and which ones aren't.
Yeah.
It used to be the case before the older judges, ended up booted off the bench that, like, for example, marijuana use mattered. And nowadays it really doesn't.
Yeah.
Even after it was legal, a judge like, for example, Judge Pomerantz, I'll call her out, she would make a big stink about it, even though it's legal. Where other judges would just blow it off.
But alcohol's legal too. And if you've got someone who is drinking too much, or somebody who's stoned all the time, I can see where that could be a factor, right?
It could. Look, you got to tie that fact to the child's best interest.
Of
How
course.
is it affecting the child? And a lot of people run in with conclusory statements. So, like, my ex is a drunk. Well, that's kind of a subjective statement, isn't it? What's a drunk? What does that mean? How often are they drinking per day? Is it impacting their work? Is it impacting the care of the child? Like, for example, has it been the case that you walked in and when you're supposed to be watching a toddler and your ex is passed out on the couch after drinking a bottle of vodka versus the guy that maybe just drinks, 3, 4, or 5 beers on the weekend when he's watching, football. So there's it's case by case, right? It depends really. And then you got to prove it, so just because, for example, your fact is that this person drinks throughout the day, a judge can make a determination on that fact by themselves, but usually you need an expert to say, yeah, this guy's got an alcohol problem. And then you got to tie that to the child's best interest. Like, how is that alcohol problem actually affecting the children? There's a lot of, in my opinion, speculation where they'll find a fact and then speculate as to what may happen in the future, where what you really have to do is show how this fact or that fact has affected, the child in the past, because we're not, supposed to speculate about the future, really. It's really about what's happened and how's that affected the child and why is it that you're asking for what you're asking for. A lot of people want to run in and get primary custody. They got to understand, for example, that the courts start with the position that the best interest of the children or the child is served by joint custody, because they've changed the rules recently and said that there's a preference that the parents share custody. A lot of judges treat that preference as a presumption. Those are two different things.
Right.
One's a legal standard that you have to overcome. The other is just a preference, a policy preference. It was already in the statutes before they changed that basically said that, the policy of the legislature is that each parent have as much time with the child as possible. So you start with that, and then you go, if you want primary, you have to move the needle and show the court that it's on the children's best interest that, that the children be with mom or dad for the majority of the time, which would be primary custody.
So, and the judge makes all of those decisions, and I'm not an attorney, but do they get any outside help to make those decisions? In other words, and I hate to say this, but all the crap that you see on TV is BS as far as I'm concerned. It doesn't really work like that.
What do you mean, like on sitcoms? Yeah, no, that's not the law. Definitely not, no. Yeah, I mean, if we get back to the idea of just understanding what the rules are. So the way that you look at the law is that you'll have a substantive rule, and it'll give you the elements that you have to satisfy in order to get the relief that you're asking for. It's the same in family court. Like I said, you have the substantive rules concerning the best interests of the children or the child. You have a whole laundry list of factors that courts are required to look at to move that needle from joint custody to primary, if that's what you want. You got to know what facts are relevant. You know, that kind of takes experience, but you know, if you look at the factors they're supposed to look at, you kind of can figure out, you know, what facts matter. So, for example, there's one factor that, what's the rule exactly? It's, you know, the courts are determined to consider which parent is more likely to foster a close and continued relationship between the child and the other parent. That's kind of the withholding, you know,
Right.
factor. If you're withholding, obviously you're not trying to foster a close and continued relationship. If you're bad mouthing the other parent, you're not fostering a close and continued relationship. So that's where you see this is the factor. Start thinking about all the facts that fall under that. You know, another one would be like courts require to consider the developmental, emotional well-being of the children. If your spouse or, you know, your ex is behaving in a way that would affect the developmental well-being of the child, like for example, if the child has a medical condition, but they're neglecting that, they don't take them to
Right.
their doctor's appointments, they're not taking them to therapists as required, or whatever the case may be, that's a relevant factor. As far as do they use other people to kind of help them assess the situation or assess the facts that litigants are asserting, yeah, they use outsourced evaluators like a child custody evaluation or a behavior order, or not a
Yeah,
behavior order,
therapists
but a
or people like that.
behavioral,
Yeah.
you know, behavioral evaluation to determine if there's any kind of, you know, personality issues or psychiatric issues that may impact children's well-being. You know, those are expert reports. They're supposed to be done in a certain way, but in family court, they're just like willy-nilly done. Where the rules of procedure, for example, require you to disclose an expert, and the other side gets a chance to. Then they have to do a report. The other side gets a chance to hire their own expert to review that report and present a rebuttal report. With family court, they just kind of choose an expert. Like if you ask for an evaluation, typically once the one side is presents three different people they want to use, and the other side picks one. Then there's a evaluation done and a report's issued from that, and then that can be used at trial if the therapist is there or the psychologist, whoever did the report, is there, and you know you can you know, ask them questions about their report or cross-examine them, whatever the case may be. So yeah, they use those. They use child interviews, for example, which aren't entirely helpful, honestly. Drug and alcohol abuse type evaluators to see if you have an issue with drug and alcohol abuse. You'll have reunification therapists that get appointed, like a notorious one like Donna Wilburn, which I would never use. So yeah, the answer to that is yes. You have to request it. You have to justify. You have to have good cause to ask for that. So if you're asking for a behavioral evaluation, the question always is why? Why am I asking for this? What am I trying to do here? What is it that I'm trying to prove? So if you're thinking that your ex has some kind of personality disorder or psychiatric condition that the court should know about, you're not, all you can testify to is the facts that you know you think justify that, and then the court has to take that and and determine if that matters or if it affects the child. But the judge isn't an expert. You're not an expert. It's a lot more compelling to have an expert with their knowledge and experience actually evaluate the facts and do their collateral interviews. And usually they just make recommendations. They won't tie or make a recommendation as to who has primary or who should have joint. I think in a custody evaluation you get that, but not in a behavioral evaluation, for example. Child interviews can be used when there's a dispute as to some fact that happens in the home and the children are witnesses to it, like domestic violence. A lot of people allege that they've been physically abused, and the other person obviously denies it. Again, somebody's lying.
Right, yeah.
So how do you figure that out? A lot of times, if the kids are of old enough and mature enough, they could say, yeah, I hear mom and dad fight, or yeah, I saw dad hit mom, with a wiffle ball bat or whatever, whatever the case may be. They could be there to corroborate stuff. But I mean, other than that, the value of those reports is, to me, a lot of times minimal.
Yeah.
Unless it's there to just corroborate some kind of, fact that you want to corroborate, or if the kids are old enough to get their opinion of who they should or who they want to live with,
Is that common of children of a certain age that the judge may ask them, what's your decision, or who would you prefer to be with, or is that?
I mean, first, they're not required to even know that there's a litigation going on. So that's one mistake a lot of parents make, is that they talk about the case to their kids. You're not supposed to do that. The local rules prohibit it. Judges frown upon it. The mechanism is to get a child interview, to have a third-party specialist, interview the kids. And again, you have to request it, and you have to justify it. A lot of the judges don't want to get kids involved if it's not necessary. So, in whatever motion, the initial temporary orders motion, a lot of people ask for that. Give me a child interview. But you got to you have to have good cause for it. It can't just be just because. A lot of people ask for that.
Well, and somebody's got to pay for that too.
Well, the child interviews done through the Family Mediation Center are free.
Okay.
But if you want, a therapist to testify, if the kid's got a therapist, for example, you want them to testify. You could do that. You could subpoena that person. Usually they don't want to get involved in these cases. It's sometimes not a good idea because it affects the relationship with the child. It's just, do children get involved? Rarely. They shouldn't be involved. They shouldn't nobody should speak to them about the case at all. But they do, and that often hurts, the person that's doing it. The problem is always proving it. People make that allegation all the time.
Right.
He's bad-mouthing me and he's saying this and that. That's where a child interview, that's where you can justify a child interview.
Right.
I'm saying he's saying all these things to my kids. My kids are coming back and telling me he's saying all this. How do you prove that?
Right.
You can't go on the stand, for example, and say this is what my kids are telling me, because that's hearsay. You can actually have the children testify if you want. There's a mechanism to do that. But again, I mean, the judges don't want to get children involved. But if they're older and they have something relevant to say and the court thinks that it'll help them make a good decision with respect to a final determination on custody, then yeah, they'll allow it.
So based on your experiences there, what do you think is the best thing about the family court here in Southern Nevada? Is there a good thing? I mean, can you say?
No, it sucks. It's terrible. I mean, it's terrible that people have to go through the process. Well,
the reason I asked you that question first is because that can lead me into, so based on your experience, what do you think some of the problems are in family court?
I mean, like I said, but one problem is the discretion the courts have. Another problem when you're a proper person, when you're proceeding on your own, is that I do think that you're at a disadvantage in those courts where the other side has an attorney, because I don't know that all the courts treat people that don't have attorneys fairly. I really don't. I don't think they allow them to say their piece. So a lot of judges will. But the problem really is that also is lies on the other side is parents not being informed, and they go in there and they just make outrageous statements, or they go in there hot, and their demeanor is such that the court's not used to seeing people have outbursts and or speaking overly harshly. There's a procedure that you have to follow in your court. If you file the motion, you go first, and then when they're done, you do your opposition. If you have a counter motion, you do it at that time. Then there's a reply. There's like a certain order of doing business, and people that are an improper person don't have a clue that order, or they'll think it's just some kind of conversation. They'll break into the middle of when somebody's speaking, and that annoys them. So you'll have the attorney that filed the initial motion saying his thing, and people are sitting there getting pissed off because they're saying all sorts of wild stuff about them, and they'll pipe up and that's not true and this kind of thing, and that's what annoys the judges. That really gets under their skin, I guess. So part of it is that, but part of it really is that you need to understand that a lot of these lawyers and judges have known each other, and so I wouldn't say there's a cabal, but there's a cabal. Some attorneys get away with murder in those courts because they know those judges, they run with them, they've come up with them, and then these judges become judges, and, that kind of mutual respect and feeling of camaraderie still exists, right?
Right.
And so you're going to get that situation where you have a lawyer that's trusted by this judge, and here you come by yourself trying to break through that. It's difficult to do. It's part of the problem with family court is that it's a small, insular, I would say almost, well, no, I'm not going to say incestuous kind of situation where they all know each other, and even as an attorney, if you're not part of that little group of attorneys that have been there all the time and that donate to the campaigns and that hang out with these judges outside of court, you're at a disadvantage.
Yeah. So the do you think that the caseload, the workload in the family court is a factor in why there's so many problems there, and that it self-perpetuates because?
I think at this point there's like 26 family court judges. There's a lot of them.
26 family court judges?
I want to say. I don't know. There's a lot. They added like 6 more on the last election, so there's a lot of them. Are they?
See, I thought there was 8 or 10. I didn't realize there were that many family court judges.
Well, don't quote me on that. I'm some kind of exaggerating.
No, I'm saying, but over 10. 10 or 15 or 20.
It was 6 departments the last time around.
Yeah.
So they're overworked. There's no doubt about it. They get, and the problem is that everybody gets the right to say their piece, right? You can't just push them away. So that's kind of the what I was saying is don't go in there making frivolous arguments because they're overloaded. They have a lot of work. And if you're walking in, they're wasting their time. They're going to get mad. They're going to be annoyed, not mad, but annoyed with you. And that's not going to bode well for you throughout the case.
One of the complaints that I've heard is that too many of the judges either don't know or don't follow the law or the rules of law. They're
I wouldn't say that. Look, I've never really seen a judge make a decision that's completely outside of their authority or what they're allowed to consider. So, each judge has his own jurisdiction. The family court judges have jurisdiction over family court matters, which are under NRS 125 usually, and 126 and 120. All those the 25 to like 30 NRS. So if they act outside the bounds of those rules, they're not following the rules, but you can't really say that they ever do that. What people complain about is this idea that they're not following the rules in the sense that
They're not agreeing with me.
Right. It's a lot of times, really, it's that they're not agreeing with me.
They're not doing what I want to do, so,
So
they're wrong.
They're wrong, and
Yeah.
they're acting outside the scope of their authority. They're acting within the scope of their authority. They just have a lot of discretion, and you do get bad rulings, and people become aggrieved, obviously, and some people get far more pissed off than others if they don't feel like they got the outcome they got. But a lot of times, I'd say most of the time, the fact that they didn't get their outcomes is because they're not versed in the procedure and the substantive law that they're supposed to use to get to where they want to go. So I'm saying it's important to understand the process, to understand the rules that you're operating under, like what you're allowed to ask for under what circumstances, things like that. People will walk in and make arguments that I think could be frivolous. Like, I've had a recent case, for example, where this guy keeps harping on the fact that his ex cheated on him. Who cares? It's irrelevant. It's a no-fault state.
Yeah.
Does that affect the children's best interest? That's the question you always have to ask yourself. You've got to tie that, whatever fact you want to use, to the
Yeah,
children's
is she
best
doing
interest.
it in the room with the kids? Or,
Exactly. They throw in orgies in front of
Right.
when the kids are in the house, and these kind of things matter. But if you're having an affair outside the home, it's irrelevant. This guy keeps harping on it and harping on it, and I could just see the judge getting more and more annoyed. And as a lawyer, I'm not there to help them, so I sit back and watch and just let them go.
So this is, I don't really expect you to know the answer to this question, but judges' rulings can be overturned by the state Supreme Court, right?
Yeah.
Do you know how the family court judges stack up against maybe the judicial or the district court judges? As far as more or less getting overturned? Or?
According to statistics that our Nevada judges puts up, they get overturned a lot more than district court judges, but that could also be because, parents appeal things more than appeals are otherwise made in district court. I don't know why that may be. I think a lot of the appellate cases that get overturned have to do with judges not making sufficient findings of fact to justify the decision that they ultimately render. That's one issue that always comes up with the Supreme Court. There's cases that stand for the proposition that you've got to go through the best interest factors, and you got to show what facts. First, make specific findings of fact. The court determines this is a fact, the court determines that's a fact, after the presentation of evidence at trial. The evidence consists of documentary documents just to prove your position and witness testimony. From that, the courts find what's credible and what's not, and those are findings of fact. And then they have to use that and run it through the best interest analysis and tie it all together in a little nice, neat bow and show how those findings that were made and applying those findings to the law, achieves or results in the conclusions that the court comes to. And a lot of times they don't do that. That doesn't happen. The lawyers are the ones that are supposed to draft those orders, so a lot of times it's their fault. Cases get overturned for sure, or due process rights aren't followed. People aren't given the opportunity to be heard, things like that. But you can appeal after a final decision. So that's the other thing people don't understand is that until the case is over and you have a final order, you can't do an appeal except under certain circumstances. You could do a writ prior to the final order, but the rules regarding writs are tight, and unless it's a big issue that's of nationwide or statewide importance, and there's no speedy alternative remedy, they won't hear those writs. You have to wait.
One or part of the family court system, if I'm not mistaken, is also where adoptions get done. Is that
Yeah.
They are part of the family court system. Have you had any experience in that area?
I haven't done many adoptions, honestly. I do, mostly what I do is just straightforward divorce and custody cases and operate in the child support courts. For example, I don't do a lot of guardianship. I don't do a lot of adoptions. I kind of vaguely understand the rules concerning that. But, first you got to terminate a parent's rights before you do an adoption.
Right. No. And I just, the reason I ask is I know a few families that have been through that process here, and they have nothing but good things to say about that system. And they said that they were helped, they started out as fosters, and they're what I call failed fosters. They ended up adopting the first two, the one couple, their first two sisters that they were fostering, they ended up adopting.
Yeah.
And they said that the foster care system and the courts and everything were extremely helpful. And because you hear about, it's so hard to adopt a kid, and they're saying,
Oh,
God,
no.
it's not.
That's
here
another. That's
in
a
Southern
whole.
Nevada. There's so many kids there, and they'll help you every step
That's
along the way.
a whole nother can of worms you're opening there. Yeah, the foster parents are happy and the adoption process is streamlined. It's how you get to that point that I have a problem with, terminating the parental rights.
Right.
A lot of times the state will bring petitions for abuse and neglect against parents, and then they just make onerous demands of them that they have to complete when they know there's no way that some of these people can do it in the time that they're required to do it. They're given something like 14 months to finish a case plan, for example. And if they don't, then the state right away moves to terminate their parental rights. And that whole time, usually the kids are in foster care. And so once the rights are terminated, it goes right into the adoption process, and they make it really easy to do that.
Well, in the cases that I'm familiar with, it was the parents who approached the foster care system to say, we just as soon terminate our rights.
That's rare.
Yeah.
I mean, that doesn't happen often, but yeah, if you agree to terminate your rights, it's a fairly simple proposition. And you file a petition to terminate your rights, and so long as the other parent's okay with it, I suppose and then you do a consent to termination, and that's it. And then you move on to the next step.
Cool. Well, now we come to the fun part, because we're getting a little short on time here. So I'm going to ask you to spill all the dirt about the family court system. What are the secrets there that nobody knows? Just the ones that you can talk about, so you won't lose your license or anything like that.
What problems?
No, I'm messing with you. So, but is there anything that you want the viewers to know about the family court systems, and anything that they, if they think they're going to end up there, is there anything that they can do, or what can they do to ensure that they're going to have maybe not the most successful, but at least a reasonable experience?
Well, first, try to get a lawyer. I mean, try to avail yourself of all the resources that are out there to get a lawyer. So you could go to the legal aid center. They may appoint you a lawyer if you don't have the money to get one yourself, or they'll reach out to attorneys to see if somebody will do a pro bono. If you can't do that, really avail yourself of the resources that are out there to understand the law. Like I said, Marshall Willick has a website where he has an enormous amount of information. Some of it's outdated, but it's helpful if you don't know what you're doing. The Self-Help Center to get your documents and your pleadings. They're not supposed to give legal advice. From time to time, they'll give advice. Generally ignore them. They're almost always wrong. Try and stay away from paralegals that'll tell you that they're going to do the pleadings for you, and all you got to do is walk into court. They are not supposed to dispense legal advice, but oftentimes, obviously, in writing these motions and doing these pleadings, they kind of have to come to legal conclusions based on the facts that are presented to them, right? So that's kind of practicing law without a license. Not that they ever prosecute that, but they could be more harmful than helpful. A lot of paralegals, for example, have an attorney that they use that'll just go in an unbundled capacity, for example. That's, in my opinion, a bad system. A lot of times those lawyers don't know your case very well. They get this stuff last minute, so you'll hear a lot of people complain that their lawyer did nothing. He just stood there and made me talk, that kind of thing. Those are those unbundled lawyers.
As an attorney, when you had talked about some of the places that if you don't have an attorney, you can go and find out about the process. And do you think that's a good idea, even if you do have an attorney, so that you have more of an understanding what's going on? And when you talk with your attorney, you may be a little better educated in what questions to ask, because if they don't ask the right questions or give you the right information, you can't really do your job as well, right?
Yeah, I mean, you need to be informed, obviously. So whether you're doing this yourself or you have an attorney, yeah, do the research and figure out if what your attorney's telling you makes sense or not. You can always go get a second opinion. There's a lot of lawyers that do free consults. I do free consults. And I'll often hear people come in and say, I got so-and-so lawyer, he's telling me so-and-so, and, I just don't think that he's helping me. And a lot of times, just as a service to the public, just because if you give them a good vibe, they'll go out there and refer you. But I'll walk them through it and be like, yeah, I think your lawyer's doing the best that he can under the circumstances. But yeah, you can always get a second opinion. Obviously, if you want, you can do the Ask a Lawyer program, even if you have a lawyer. Just be like, here's what my lawyer's doing. A lot of lawyers are averse to stepping on toes, though, so they're not going to necessarily tell you that your lawyer's not doing a good job, unless they want your money, and then you got to really, whatever it is they're telling you, take it with a grain of salt. But if it comes to representing yourself, just know the process. It's really straightforward, honestly. You have the case initiates with a complaint that's filed by one or the other party. They're listing there what they want out of the divorce. Usually in family court, the complaints are really bare bones. Like, I want joint primary custody, whatever. I want, medical insurance, attorney's fees. For custody cases, that's all that's at issue. Just support, visitation, or the designation of the custodial designation, and attorney's fees. Divorce is now a little more complicated, but to go from the complaint, you serve it, you got 21 days to respond if you get served. Just recently changed that from 20 days. You do your answer, so they'll list what they want in paragraph 1 through whatever. And you answer it by either admitting or denying their paragraphs, and you do your counterclaim, what you want. And then what follows is an initial motion for temporary orders. It's very important to understand that that's what kicks off your case, really, and gives the court an idea of what the issues are in the case.
What's the worst thing about being an attorney for you?
I don't know that there's a worse thing.
All right, what do you hate the most?
What do I hate the most?
What do you hate the most about being an attorney?
I don't know that I hate it. I've done it so long now that it's like I'm immune to all the stuff that attorneys would otherwise say they hate. Like, complaining clients, the difficult clients to deal with, other attorneys, judges that you don't necessarily agree with or get along with.
Or unprepared?
Unprepared. I mean, you hear a lot of that. Oh, my judge wasn't ready. He didn't know my case. But I haven't really run into that. And that's what oral argument's for. That's why I'm saying that initial motion is very important, where you lay out, the facts that you think are relevant to your case. The facts that you lay out have to relate back to the elements of the law. And so, in other words, you got to understand the best interest factors.
Yeah.
When you're laying out, for example, in a custody matter, when you're asking for primary or whatever, you got to know what the best interest factors are, and from that you get what facts are relevant and you write down your facts, and then you're asked, what do you want? Based on that, you got to run through the best interest analysis. Why does this fact matter under this factor? Why does this fact matter under that factor? How does it impact your kids? So that initial motion is really important. So that's where I would say, once you have it knocked out and you're ready to file that, go see a lawyer first. Go to ask a lawyer. Maybe if there's one that's willing to do a free consult, just to go over stuff with you, see if they're willing to do that. I would be inclined, if there's a case in progress and somebody's like, look, I need somebody to review this for me or see what I could do. I'd take that, just because that might turn into a client,
Yeah.
And just sit down and talk with them for a little bit. But because those initial motions, I think, are so important, they're going to lead to the initial temporary orders pending trial, and that could be months and months and months away. It's important to understand what the substantive law that the court's going to be looking at is, what the standards are, and what facts that you're going to use in support of your case, and then just going into the hearings, you need to know how. I think it would be helpful if they sat in on some of those hearings and just saw how the process goes. Like I said, you got the initial person filing the motion's going to make their argument, and then the other side gets to oppose it, and then there's a rebuttal, and the court's ready to rule. Don't interrupt people. Don't walk in there with an attitude. Don't go in there ready to, with your, look, even if you think the courts are corrupt, even if you think that the judges don't know what they're doing, even if you have strongly held beliefs concerning that, you got to leave those at the door, because that's the person that's going to make a decision on your case.
Okay, so as a representative of our Nevada judges, I am required by law to ask this question. Do you think that cameras would help in the courtroom?
Yeah, I think they would. I think to the extent that, look, what tells you, what fact is it that kind of demonstrates to you why cameras matter in family court? It's the resistance you get from lawyers and some judges from hearing these matters. Nobody wants.
I do understand the privacy angle. I mean, because you're dealing with families, and you're dealing with children, and there's things that may or may not affect those families because there is a camera in there and the public can see that. But in most cases, I'm asking, I don't know this, aren't the courts open to the public coming in, or is that not the case in family court?
Well, look, there's a decision that just came out that implicates that question. The Abrams versus Sanson case came out and said that, particularly with respect to attorneys, that we're essentially public figures and what we do matters in the courts, right? Obviously, judges as elected officials, what they do should be open to inspection to the public. You could do all that without naming names, without showing who these people are, or I think it's a weird situation in family court, because it's kind of a private matter. Does anybody
allowing the cameras in the court and not making it public after the fact? Do you think that would be helpful? Because this is, well, the judge told me this, and the judge says, well, no, I didn't. That's not on the record. But wait a minute, the camera shows, this is what you said.
It's already being recorded.
Oh, it is? Okay.
Yeah,
I'm
there's
sorry.
already a record of it. So as an attorney, or even as a litigant, if it's your case, even if the case is sealed, if you're the attorney of record or litigant in it, you have access to those videos. You just have to request them. But the broader picture is, should the public at large
right,
be able to view these private proceedings? I'll tell you, my case is sealed, for example. I didn't ask for it. I actually had it sealed by my attorney, as they do as a matter of routine. But in my case, for example, there's a separate confidentiality agreement which covers a lot of stuff. So, that's a good question, really. Should divorce in custody matters be open to the public at large? If the case isn't sealed and, somebody can walk into court and just sit there and observe, then I don't see the difference between that and broadcasting it.
Right. So the unless the judge says this is a closed hearing, myself as a private citizen could walk into one of these cases and just sit there and observe, right?
Right. You can, yeah. So
if that's the case,
why not
the
broadcast?
cameras? Right.
Well, yeah, because it reaches a larger audience, and then it implicates the conduct of the attorneys that the cabal.
But isn't that what we want? Don't we want judges and attorneys to be accountable to the general public?
When I was in family court, it's a long story. You ready for the story?
Sure.
When I was in family court, I believed that family court all courts should be open to the press. Because I honestly believe, and I believe to this day, that the only thing that closed courtrooms do is they foster bad judging, bad lawyering. The public pays for a very expensive judicial system, and the public has a right to see that that law is being dispensed appropriately. And I believe that in the family court as well. So during a period of time when they were having these debates about whether it should be open, I opened my courtroom.
Yeah, I think
because you're supposed to be there in our best interest, and if you are not serving our best interest, I mean, it's another way. I think, and this is another personal opinion, and I'm just a lay person, but my experience has been that too many people have no clue who they're voting for when they go into the voting booth, and I say this all the time. Judges, your school board, your city council, your mayor, all of these people, the board of supervisors, they affect our lives on a daily basis. They are the most important people in our daily lives on that ballot. And too many people never go that far down.
No, especially not in judicial elections. I mean, there are there's very few people that actually vote. And when they do, it's usually like I'll get calls around voting time and what judge should I vote for? They have no real way of evaluating it because it's difficult to actually, get these videos or sit in on these hearings because there are times during, your work hours or you just don't understand how to, for example, get the videos to view them. So yeah, I think it matters. I think you got to balance that with the party's privacy rights overall.
Right. That's a tough call. I mean, in the family court system, I can understand that more, but I can also understand the reluctance. I mean, I the more you resist doing that, the more I want to do it.
And I really felt that the family court was a place that should be open to the press.
Yes.
Because at that time in New York, and probably in a lot of other places, it was sort of the dumping ground for morons and political hacks. People who had gone around and collected signatures for politicians to get on the ballot. They say, we owe them a favor.
Yeah.
And where are we going to put them? We can't put them in the civil court or the Supreme Court because press goes in there to report. So we have to put them in a place where nobody can see the morons that we're pointing to the court. Now, I know that because I worked in the family court as a lawyer.
Yeah.
And it was frightening to see the mentality of people who were impacting on the lives of families and children.
The judges.
The judges. So I thought it was a great idea to have cameras in the courtroom when I became a family court judge.
Well, yeah,
what I mean?
that's
Because
human nature, isn't it?
Yeah, because it is. It's just like, what are you hiding?
I think there's a manner where you can.
Because they want to put wait. They want to put cameras in classrooms.
Yeah, that's
right.
Fair, yeah,
that's a big push. Let's put cameras in the classroom so we can watch the teachers, indoctrinating our kids. So,
Yeah, you just have to balance you got to figure it out. Look, balance the rights. So you have the right of the public to know what their elected officials and officers of the court are doing against the litigants' privacy rights, and certainly a child's privacy rights. 'Cause
Yes.
they're not, they're not asking for any of this shit,
yeah,
So I think there's a way to do it where you blur out faces, you don't name names, you don't cite the case number, for example. Just like this is the department and this is the case, or this is what the issue is, and watch them go at it. But I think definitely, if it's going to happen, in terms of putting publicizing these family court matters, you should consider the people that are going through that
Right.
nightmare. Got to consider their
well,
privacy.
and as a video editor, I know that you
you can do that, right?
beep out certain, facts or names or places or dates or something like that, and still present the case
Right.
in a
Then
reasonable way.
you can still see, the way that lawyers
Right.
behave in court, and you can still see how judges handle matters, and I think that would be helpful to the public. I think, especially in divorce matters, it's really just you got to balance these people's rights to privacy against the public's right to know.
Well, and I'm sorry, but we are running out of time, so I want to make sure that you tell the viewers how they can contact you if they're interested in maybe hiring you, or if they know they're going into family court, if you'll help them go into battle, or where can they contact you?
Yeah, so my office number is 978-7090, Alex Ghibaudo. My office is in the Arts District on the corner of California and Casino Center. So just call and make an appointment. Yeah, I think even online my cell number's there. You can always text me. Yeah, that's it. Alex Ghibaudo PC. And just call the office and make an appointment.
All right. Alex, thank you for coming in. I appreciate it. It's always good to, what we try to do here is educate people about the law and about who to vote for and stuff like that. You're not running for anything this time around, are you?
No.
Got any plans to do that?
No, sir. No, thank you.
See, you're like me. You're smarter than that. Rather be the power behind the throne. And hey, we thank you all for coming and watching us, and hopefully you learned a little something. And you know where to send your cards and letters. If you want to complain about anything, call 1-800. No, I'm not going to give that number out. Anyway, thank you all for joining us, and we'll see you next time on Our Nevada Judges.